And there you have it, viewers. It appears that these police officers from the Bahamas.
Welcome to another episode on the La Rapport, my fourth episode for 2023. This is episode 45. Today I'm going to look at the defense of duress in criminal cases. And I was moved to look at this defense based on a conversation that I had with one of my colleagues, who informed me that he intends to rely on this defense in an upcoming criminal trial. I'll be back to discuss this defense in details. But before I do, my usual disclaimer: this is not legal advice, should not be construed as legal advice, and for legal advice, please contact an attorney of your choice. Welcome back. The defense of duress is a defense at common law to all crimes except murder, attempted murder, and treason involving the death of the sovereign. And this was decided in the case of the Queen and Guts of 1992. The defense is not available to a person charged with murder as a principal or as an aider, abettor, counselor, or procurer. This was decided in the case of the Queen and How, 1987. It is, however, available on the charge of conspiracy to commit murder. This was decided in the case of the Queen and Ness and Awan in 2011. So what is the defense of duress? What is the nature of the defense? There is no definite statement of the scope of the common law defense of duress. However, a distillation of various authorities has led the Court of Appeal in the case of the Queen and Graham to pose the following two questions in relation to duress. Question 1: was the defendant impelled to act because, as a result of what he reasonably believed the coercer had said or done, he had a good cause to fear death or serious injury? And 2, have the prosecution proven that a sober person of reasonable firmness, sharing the defendant's characteristics, would not have responded in the same way? All of the authorities recognizing duress as a defense have involved threats of death or grievous bodily harm. In the case of the Queen and Quayle in 2005, it was held that an imminent danger of physical injury was required. A threat of serious psychological injury will not suffice. This was decided in the case of the Queen and Baker, 1997. The check may relate to the defendant or a member of his immediate family, or alternatively to a person for whose safety the defendant would reasonably regard as his responsibility. And this was decided in the case of the Queen and Wright 2000. The fact that the defendant believes that the check will be carried out if he does not commit the offense is not of itself sufficient. This is unless it can be shown that a person of reasonable firmness sharing the characteristics of the defendant would not have yielded to the check. Again, this was established in the case of the Queen and Howe, 1987. As a result, the defendant believed in the check must be objectively reasonable as well as subjectively genuine. This was established in the case of R versus Hassan, or the Queen versus Hassan, 2005. So the defendant must have a reasonably objective belief as well as subjectively, meaning, in my respectful view, that when the check is assessed objectively by the ordinary man, they must have come to the same conclusion that the defendant was in imminent danger, as the defendant own subjective personal understanding of the check he faced. When considering the characteristics of the defendant, pregnancy, serious physical disability, or recognized mental illness may be relevant. However, in most cases, it is probably only the age and sex of the defendant that is capable of being relevant. A person of low IQ or low IQ is not a relevant characteristic, nor is suggestibility or susceptibility to pressure, unless this is a result of some mental illness, mental impairment, or recognized psychiatric condition. And this was established in the case of Queen and Boyne of 1996. So if a person is susceptible or suggestible to pressure, easily led astray, this is not relevant unless it could be shown that that person has some mental illness or impairment. What is also interesting is that reference to a person of reasonable firmness makes it clear that intoxication cannot be irrelevant characteristics. So if a person is intoxicated, that is not relevant to the defense of duress. The defense will only be available where a defendant has been subjected to threats directing him to commit a specific crime, and he has complied by committing that crime. It is not available where the defendant has committed a crime in order to escape from other unrelated demands. For example, in the case of the Queen and Cole of 1994, the appellant in this case, the defendant, borrowed money from a loan shark. The loan shark threatened him and his girlfriend with serious violence unless he repaid the money. The appellant then robbed several building societies in order to repay the money. The Court of Appeal held that the defense of Duress was not available to him, as there was not a sufficient nexus between the threat and the crime. The loan shark had not told the appellant to commit a crime in order to repay the money. So there must be a nexus between the crime committed and the threat received by the threat received by the defendant. Now, it is essential that the threat should be effective at the time the offence was committed. This was established in the case of the Queen and Hammond, 2013. The defense of Duress was held to have been correctly withdrawn from the jury because the evidence could not satisfy the requirement that the threat must be imminent or immediate and have been operating and the actions which constitute the criminal conduct. It is always open to the prosecution to prove that the defendant failed to avail himself of an opportunity which was reasonably open to him to render the threat ineffective. Upon that being proved, the defendant can no longer rely upon the threat in question. And if we look at the case of the Queen and Bianco, 2002, Archibald News 2, Court of Appeal, these issues have been fleshed out in these cases. In the Queen and Hassan, Lord Bingham stated that if there is a threat, it is not such as a reason to expect to follow immediately or almost immediately upon his failure to comply with the threat. There may be little, if any, room for doubt that he could have taken evasive action, whether by going to the police in some other way to avoid committing the crime with which he is charged. So, if there is any opportunity whatsoever to render the threat ineffective, whether by going to the police and having the person or persons threatening the defendant arrested, the defendant must avail himself of that opportunity, or he runs the risk of having the defense not made out. And this was confirmed in the case of the Queen and Bachelor of 2013, where it was held that the defense of Duress was correctly withheld from the jury, where the defendant could have gone to the police at any time over a period of 2.5 years, and he could not reasonably believe that the execution of the threat was imminent or immediate. So, it is clear that the threat must be an immediate and imminent threat to the defendants. Once the defendant has raised sufficient evidence of duress to allow it to be considered by the judge, the jury, or the magistrate, the legal burden then shifts or falls on the prosecution to prove beyond a reasonable doubt that the defendant was not acting under duress. And this is and has always been the correct principle of law, that when a special defense is raised, it is for the prosecution to disprove that defense. And here is where I will end this episode today. Thank you for watching, and I will see you in another episode.